I want to see us working together to conduct responsible oversight of the Internal Revenue Service. With that, I yield back, Mr. Chairman.
I would just point out that, well, first of all, Ms. Mitchell doesn't represent progressive groups because it sounds like, according to Mr. Sekulow, they don't need it. They were 7 for 7.
Yeah, I'd urge you to have some come over here and testify and find out what they were asked.
The minority had 9 days notice of this hearing. They could have got a witness here. Maybe you want to go get one of those 7 who got approved out of the 7 who were put on some notice. But what the committee did, what the minority did have time to do was to write me a letter urging me not to pursue having Barbara Bosserman come here and answer our questions. You had time for that, but you didn't have time to find someone to come testify? Recognize the gentleman from South Carolina.
Thank you, Mr. Chairman. I'm a lot more interested in having a balanced investigation than I am a balanced hearing. And in that light, Ms. Eckelbrett, did you hear the President say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the President say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the President says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about? Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the President say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the President how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that?
Mr. Gowdy, if I may, she invoked her Fifth Amendment privilege, which she has the right to do, of course, and you and I both respect that, because we now know the reason why. It wasn't perhaps as clear as it was made yesterday. She invoked her Fifth Amendment privilege because she knew, after she made a false statement and a planted question at an ABA meeting, she knew that, in fact, there was her words and her emails, off-plan drafting of rules targeting conservative groups. She also said at a Duke Law Forum that people are asking us what we can do, and she said, I can't do anything until I see the 990s, the tax returns that are filed. That was all going on while she was redrafting the rules with the highest level of the Chief Counsel's office. Mr. Cartwright.
Mr. Sekulow,
yes,
I want to say this. I understand why she invoked her Fifth Amendment privilege. I don't understand why in the hell the President of the United States would prejudge an investigation
I don't either.
before any of your clients were interviewed, before either of these 2 victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these 2 victims were interviewed. He has gone on national television. He has prejudged the investigation, and in my judgment has compromised the Department of Justice, which leads me to this question, Mr. Sekulow.
Yes, sir.
There is the option, when you have a compromised investigation and a chief executive who has prejudged the outcome before the jury's even gotten all the evidence, he's got an option of appointing a special counsel, right?
Yes, he does.
And the special counsel regulation says if it's extraordinary circumstances that furthers the public interest. Can you think of anything more extraordinary than government targeting people based on their political beliefs?
No, I agree with you 100%. And I also would point to again, the email of June 14, 2012, which was just released because this shows the need for a special prosecutor at this point on the criminal aspect of this. And again, Mr. Cartwright, when you asked about the no evidence of politics, let me quote from the email. Don't know who in your organization is keeping tabs on C4s, but since we mentioned potentially addressing them off-plan in 2013, I've got my radar up, and this seemed interesting. These are coming from the most senior people within the Chief Counsel's Office of the IRS, which is a presidential appointee. Again, it's an office I came out of, so I have due respect for the office. But at this point, a special prosecutor to evaluate the criminal sanctions or criminal laws applicable would probably be the best, I believe would be the best way to go, because I don't think the Justice Department right now, again, with due respect to the Justice Department, is institutionally capable of doing this. And I need to say this also, because I thought that the question, Mr. Cartwright, on Ms. Mitchell's legal representation, she has an exceptionally excellent reputation in this town as a lawyer. And her clients tend to be conservative because that's who her clients tend to be. But, you know, I'm a conservative also, but like I said, I've represented the American Civil Liberties Union in cases at the Supreme Court of the United States. I've represented the National Democratic Policy Committee as well. So I don't think it's fair to go after the lawyers in a situation where it is the IRS that is trying to use their procedures to justify their illegal conduct. Remember the apology? They offered the apology, you know.
For all three of you. But during the ranking member's opening statement, as I shared with him on the floor, my mind went away from the questions, and I went back to South Carolina in the very same month, the very same year that the IRS was conferencing in Anaheim. We were furloughing law enforcement officers. We were furloughing teachers. Prosecutors in my own office were furloughed. Secretaries in my own office were furloughed. Those are secretaries who struggle to make ends meet under the best of circumstances. And here we're asking them to go 2 weeks without pay, and we canceled all out-of-town training. We brought our own food to our Thanksgiving and Christmas office socials. We started an anonymous fund to help our fellow employees who were struggling to make ends meet. And one night, one of my secretaries came in after hours and asked if she could borrow the money to buy her child a birthday present. And she kept apologizing for having to do it. She kept saying, "I'll pay you back. I'll pay you back." And at exactly the same time, that young government employee, single mom, was borrowing money for a child's birthday present, other government employees were staying in $3,500 a night rooms. Other government employees were spending more money on promotional materials than that young woman makes in a year. And other government employees were spending more money on audience participation tools than that young woman makes in a year. So, Mr. Inspector General, I appreciate the work that you've done, but with all due respect, this is not a training issue. This cannot be solved with another webinar. This can't be solved with just one more recommendation. If we can just get that recommendation implemented, we're just one recommendation away from people acting responsibly. Mr. Inspector General, we can adopt all the recommendations you can possibly conceive of. I'll just tell you, it strikes me, and maybe it's just me, but it strikes me as a cultural, systemic, character, moral issue. The IRS has been in existence, depending on how you want to count, either since 1862 or 1918. But in either event, they've had 100 years to figure out that while your fellow Americans are losing their jobs and their health insurance and their homes, you do not spend $4 million at a conference for which there is no accountability. You do not hire people to make meaningless speeches or artists to paint paintings of Bono. when your fellow citizens, the ones who pay your salary, are struggling, that is a character issue. Training cannot fix that. They sent more than 25 employees on a scouting trip to see whether or not the hotel was okay. That's not going to be fixed with training, Mr. Inspector General. When you got law enforcement officers being furloughed and you've had 100 years to figure out how to act appropriately, you don't need an IG report to tell you that spending $27,000 for someone to talk about how random combinations of ideas can drive radical innovations, there's not a webinar in the world that's going to fix that. So, Mr. Inspector General, in reality, it just strikes me that we just need one single recommendation. Start over. This entity has not only targeted citizens that it was supposed to serve, it's allowed itself to be used as a political tool. Not only does it have access to our financial information, it will soon have access to our health information. Those are details that we don't share with people that we do trust. And we're going to be asked to share it with people who are so disconnected as to spend this amount of money while our fellow citizens are struggling mightily in the fall of 2010. I don't think training is going to fix it. I think replacement might. Thank the gentleman from New York. The chair will now recognize himself for 5 minutes of questions. It strikes me that the law can require action or forbid action. The law can forbid the possession of child pornography. The law can, in some instances, require you to file an income tax return. Mr. Lazarus, is the chief executive constitutionally capable of ignoring both categories of law?
Well, as I said several times, Congressman Gowdy, the President cannot refuse to apply or enforce a law for policy reasons.
Well, let's analyze that for a second. Congress decided in its collective wisdom that if you possess X amount of a controlled substance, you are going to get X amount of time in prison. You may like mandatory minimums, you may not like them. This administration summarily dispensed with that law. So my question to you, again, is can the chief executive fail to enforce categories of law that are both permissive and mandatory?
Well, it is well established that the executive branch has prosecutorial discretion to decline enforcement.
And what are the limits of that prosecutorial discretion?
You know, very frankly, I'm not an expert on that.
Well, let me ask you this. Can the president, let's assume that a statute required you to show 2 pieces of identification to purchase a firearm. Can the chief executive knock that down to 1?
I guess I'd have to know a little bit more, but I would...
It's a very simple fact pattern. You have to show 2 forms of ID to possess or purchase a firearm, Can the chief executive, under his pardon authority or his prosecutorial discretion authority, knock that down to just 1 form of identification?
Well, I'm not aware of limits on the president's pardon authority.
So you would say he could?
Under the pardon authority, the president can pardon just about anyone, not that he should. No.
Even before the act is committed?
That's the reason for...
Can he do it before the act is committed? That's my question.
I'm sorry?
Can he do it before the act is committed?
Again, that's above my pay grade. I don't really know that.
If the president can fail to enforce immigration laws, can the president likewise fail to enforce election laws?
Whether the president can pardon someone before a prosecution is initiated or before an act...
Well, I think I know the answer to that question. My question was before the act was committed. He certainly can before the prosecution. My question is this: if you can dispense with immigration laws or marijuana laws or mandatory minimums, can you also dispense with election laws?
Again, I think we've gone over this ground many times.
Well, just humor me. Let's do it one more time. Can the president suspend election laws?
No.
Why not? If he can suspend mandatory minimum and immigration laws, why not election laws?
Because we live in a government of laws, and the president is bound to obey them and apply them.
Well, he's not applying the ACA, and he's not applying immigration laws, and he's not applying marijuana laws, and he's not applying mandatory minimums. What's the difference with election laws?
We have a disagreement as to whether, in fact, he is applying those laws.
Did
My
he?
view is that he is applying those laws.
Did Eric Holder instruct his prosecutors to no longer follow the mandatory minimums with respect to charging decisions?
Now, this is an area where I really don't know nearly as much as you do, Congressman.
I'd find that shocking that anybody would not know more than I do on any topic. Who would you like me? You want me to ask Professor Turley?
That my impression is that he's not exactly doing what you've just said.
Well, tell me how I'm wrong, because Eric Holder sent out a memo that we are no longer going to put in the indictment the drug amounts. Do you agree with me that Congress can pass mandatory minimums?
Constitutionally, yes.
Do you agree that Congress can pass statutory maximums?
Pardon me?
Can Congress also pass statutory maximums? In other words, you can't get more than 30 years for a crime.
Of course.
Can a president exceed a statutory maximum?
Can he extinguish, did you say?
No, can he exceed it?
Can he exceed it? Well, how would he do that? I mean, keep someone in prison beyond his prison term.
Well, if you can put them in prison for less time than Congress says is the law, can you also do it for more time than Congress says is the law?
It's really, it's not, this is kind of fruitless because it's an area that I really don't know.
Professor Turley, what are the limits of prosecutorial discretion? And if the president can suspend immigration laws, marijuana laws, why not election laws?
Well, I think that in some of these areas I can't imagine can be justified through prosecutorial discretion. It's not prosecutorial discretion to go into a law and say an entire category of people will no longer be subject to the law. That's a legislative decision. Prosecutorial discretion is a case-by-case decision that is made by the Department of Justice. When the Department of Justice starts to say, we're going to extend that to whole sections of laws, then they are engaging in a legislative act, not an act of prosecutorial discretion. Wherever the line is drawn, it's got to be drawn somewhere from here. It can't include categorical rejections of the application of the law to millions of people.
Well, my time is up, but I would just tell you that I always thought prosecutorial discretion was an individual prosecutor determining whether she or he has enough facts to substantially result in a conviction on a case-by-case basis. If a president is ignoring entire categories of the law, whether it be immigration, marijuana, mandatory minimum, the ACA, what is the remedy for the legislative branch?
Well, first of all, the first part of that question is, as you may know, I do criminal defense work. I would never go to a prosecutor and say, I want your prosecutorial discretion to say that the entire class of which my client belongs cannot be subject to this law, because prosecutors would look at me and say, are you insane? I am not Congress. So I wouldn't even raise the question. Now, in terms of where we go from here, I'm not too sure, because the great concern I have for this body is that it's not only being circumvented, but it is also being denied the ability to enforce its inherent powers. Many of these questions are not close in my view. The president is outside the line. But it has to go in front of a court, and that court has to grant review. And that's where we have the most serious constitutional crisis I view in my lifetime. And that is, this body is becoming less and less relevant.
With that, we would recognize the gentlelady from Texas, Ms. Jackson Lee.
Let me thank.
So I hope I do live long enough to hold a Republican president to the exact same standard that I'm holding this one. But for you to run to race as the explanation for why we hold the position that we do, Harry Reid had a very different perspective on recess appointments when there was a Texan in the White House, and none of us accused him of geographic discrimination. In fact, hell, for that matter, Senator Obama had a different perspective on executive overreach than President Obama. And nobody runs to race as an explanation for that. So I would just caution you to be careful when you try to import motives to people.
Do you think not being a politician is a defense?
And is that your defense this morning? I mean, I know initially you said that you offered these comments at a conference. I think you meant conferences, plural, but you said conference when you went on a very obscure television show and initially apologized for what you said were inappropriate comments. And now today your defense is that you're not a politician. Is that the best you can come up with? Who in Libya were we to call? Who? Mr. Cummings' point is a wonderful point. It was so good the 1999 ARB made the recommendation. Make sure the host country is aware of its obligations. Who did we call in Libya?
Question, sir?
Yeah, when I pause, that's generally an indication I'm waiting on you to answer, but I'll make it more clear in the future. So you're a professor at MIT and you're worried about not looking smart enough?
Yes.
Well, you succeeded, if that was your goal. You see a trend developing here, Professor Gruber?
I don't understand the question.
It's a lot of stupid quotes you've made. That's the trend. And what I'm struggling with is whether your apology is because you said it or because you meant it. If it's good enough for us to ask brand new citizens to affirm their devotion to the law, is it too much to ask that the president do the same? If a president... So give me all the evidence to back the vehicle backfiring narrative, because we already know all the evidence to support the shooting. Give me all the evidence that made your department so sure that it was a vehicle backfiring that you didn't even search the White House. And while you are free to stand and clap when any president comes into this hallowed chamber and promises to do it with or without you, I will never stand and clap when any president, no matter whether he's your party or mine, promises to make us a constitutional anomaly and an afterthought. We make law. So I was sitting there, Dr. Lurie, thinking, here we have a doctor with an incredible background in medicine who also happens to have planned for crises like Ebola, whose job description also includes communication strategy. So why in the hell did the president pick a lawyer to be the Ebola czar and not you? I mean, God forbid we pick somebody with a background in medicine instead of a dadgum lawyer. This is just processing a crime scene, Director. This is not high math. It is processing a crime scene. You actually don't need 18 weeks of training to be able to do that. You just need to walk around. So why wasn't it done?
It is my understanding that a perimeter sweep was done. Was it as thorough as it needed to be?
Evidently not. Evidently not.
Gentleman's time is...
The next time there's an opening on the Supreme Court, I want you to see whether or not the president considers a doctor or a dentist for that job. And we actually are about to have a vacancy for our Attorney General. And I want you to consider or be mindful of whether or not he considers maybe like a tattoo artist to be our next Attorney General. I promise he will not. He will pick a lawyer for the Supreme Court, and he will pick a lawyer to be the head of the Attorney General of the Department of Justice. I'm just lost as to why he wouldn't pick somebody with a medical or health care background to be the Ebola czar.
I wish I saw the connection here, but...
I'll give you the connection. Lois Lerner just referred to conservatives as an obscene body part, and she said we were crazies and likened us to terrorists.
Well, Mr. Chairman, if...
You are not recognized. The gentleman from Georgia is not recognized.
Well, would the gentleman yield?
No, sir, I will not.
They actually, my understanding, like our criminal investigation...
You should go back. It might be the same people who gave you the understanding that you were confirmed that the tapes don't exist. So my advice is to be very careful who you take your advice from. And I'm going to say this in conclusion. Mr. Koskin, I really could not believe the colloquy that you have with one of our colleagues about the morale at the IRS. It takes a lot to stun me, but that stunned me. Here's a piece of advice I would give. If the folks like Lois Lerner and others would have spent more time working on the backlog, more time working on their caseload and less time targeting groups and less time trying to overturn Supreme Court decisions they didn't agree with, maybe morale would be better and maybe their backlogs would be lessened.
Would the gentleman yield?
I'd be thrilled to.
We now go to the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Commissioner, you're an attorney. Can you explain for our fellow citizens what the phrase spoliation of evidence means?
I have no idea what that means.
Well, I'm going to help you with it. Okay? Spoliation of evidence is when a party fails to preserve evidence. There's a negative inference that the jury can draw from their failure to preserve the evidence. You with me? If you destroy documents, the jury can infer that those documents weren't going to be good for you. If you fail to keep documents, the jury can infer that those documents were not going to be good for you. You've heard the phrase spoliation of evidence, haven't you?
I can't recall ever hearing it.
It's true in administrative hearings, civil hearings, criminal hearings.
I practiced law once 45 years ago, gave it up for Lent 1 year, never went back.
All right. Well, let me tell you what you would have found if you'd stuck with it. When a party has a duty to preserve evidence or records and they fail to do so, there is a negative inference that is drawn from their failure to preserve the evidence. It's common sense, right? If you destroyed something, the jury has a right to infer that whatever you destroyed would not have been good for you, or else every litigant would destroy whatever evidence was detrimental to them. Agreed?
I'm not sure. I think if you destroy the evidence and people could prove it, it wouldn't be a good thing for your defense.
Well, no, it's worse than that. The jury can draw, and they're instructed, they can draw a negative inference.
All right.
And that's true if a taxpayer is being sued by the IRS administratively, civilly, or prosecuted criminally, and they fail to keep documents, the jury can draw a negative inference from the fact that they didn't keep receipts or emails or documents. So if it's true and applies to a taxpayer, it ought to apply to the IRS as well. Agreed?
Is this a trial? Is this a jury? Is that what you're...
I said administrative, civil, or criminal. If you want to go down that road, I'm happy to go down it with you, Commissioner. In fact, I'm glad you mentioned it. You have already said multiple times today that there was no evidence that you found of any criminal wrongdoing. I want you to tell me what criminal statutes you've evaluated.
I have not looked at any.
Well, then how can you possibly tell our fellow citizens that there's no criminal wrongdoing if you don't even know what statutes to look at?
Because I've seen no evidence that anyone consciously...
Well, how would you know what elements of the crime existed? You don't even know what statutes are at play. I'm going to ask you again. What statutes have you evaluated?
I think you can rely on common sense that nothing I have seen...
Common sense. Instead of the criminal code, you want to rely on common sense. No, Mr. You can shake your head all you want to, Commissioner. You have said today that there's no evidence of criminal wrongdoing. And I'm asking you what criminal statutes you have reviewed to reach that conclusion.
I have reviewed no criminal statute.
All right, so you don't have any idea whether there's any criminal conduct or not because you don't know the elements of the offense.
I have seen no evidence of wrongdoing.
Oh, well, that's very different than no evidence of criminal misconduct, Commissioner.
Well, it seems to me if you haven't done wrongdoing, it'd be pretty hard to argue that you've had some criminal violation if you didn't.
Well, what did Lois Lerner mean when she said perhaps the FEC will save the day?
I have no idea
what did she say? What did she mean when she said we need a project, but we need to be careful that it doesn't appear to be per se political? You don't think that's a potential violation of 18242?
I have no idea if it...
Because you haven't looked at 18242, and you don't have any idea, Commissioner, you don't have any idea whether there's any criminal wrongdoing or not.
With regard to the production of the evidence, the production of Lois Lerner emails, I have seen no evidence of wrongdoing. What else went on?
Well, if there were, that would be a separate criminal offense.
What else went on with Lois Lerner, I said in the past...
So what you're saying is you don't have any idea whether she engaged in criminal wrongdoing. You're just saying that you did not engage in any with respect to the emails.
I haven't seen any wrongdoing with regard to the production of Lois Lerner emails.
But you are not saying there was no criminal wrongdoing with respect to the targeting of conservative groups. I want to be very clear. You're not saying that.
I've made no judgments.
So you disagree with the president when he says there's not a smidgen of corruption?
There are people who have been making judgments both sides about whether there were...
And you know what? I'm not one of those. I'm just simply saying we will never know because you didn't keep the evidence. The evidence was spoliated. And whether it's negligent, whether it's intentional, whether it's reckless, we still don't have the evidence, Commissioner.
Well, you have the evidence that there is no emails from the White House. You have all of the Treasury emails. So the basic premise that this was an argument in a conspiracy driven by the White House does not.
No, sir, you're wrong about that. You're wrong about that. That you're repeating a talking point from our colleagues on the other side that we're obsessed with the White House. It was Jay Carney who perpetuated the myth that it was 2 rogue agents in Ohio. It wasn't any of us. Was that accurate? Was that first initial line of defense that this is just 2 rogue agents in Ohio? Was that accurate, Commissioner?
Not that I know of.
All right, so that wasn't accurate, and that came from the White House. Who said there's not a smidgen of corruption? Who said that, Commissioner?
My understanding is that was the president.
Or it was the president. So that's Jay Carney and the president both inserting themselves into the IRS scandal. And you want to blame us for bringing the White House into it?
I haven't blamed you at all.
You just did, Commissioner. You just did.
Well, it's a good argument. All I said was the White House has revealed there were no Lois Lerner emails. Treasury has given you all of their emails. So to the extent that the argument was that Lois Lerner was conspiring and emailing back and forth, thus far, I haven't seen any.
Well, you can be engaged in a conspiracy that doesn't include the White House.
Gentlemen.
Good.